Good afternoon. Keep eating. One of the rules of these lunches, and this is our 18th jury improvement lunch held around the country. So we have done these, and what we have found is that it's essential that we end promptly at 1:30 so that the judges who are hopefully trying jury cases in this community can get back to their juries. I'm Steve Sussman, the executive director of the Civil Jury Project. For 50 years, I tried jury cases, and now for the rest of my productive life, I'm determined to try to save them from becoming extinct. The Civil Jury Project at NYU was started several years ago as the only academic center in the country devoted exclusively to studying why jury trials were so important to our founding fathers that they mention the right to jury trials in five places in our founding documents: in the Declaration of Independence, in the Constitution itself, Article 3, and in 3 of the Bill of Rights. Why is it in this country that jury trials are so much a part of the DNA of the justice system that there's not a courthouse anywhere in the country that doesn't have a jury box in every courtroom? And yet, we all know the sad fact is that trial by jury is vanishing in this country. And this slide shows why most of the jury boxes and jury assembly rooms like this are sitting empty these days. For the last 55 years, since 1962, the number of jury trials, which are the red squares, have dropped from 10 to 2. That's a huge drop. That's the number of jury trials per authorized federal judgeship. And you will note up here that it's not just a problem of disappearing jury trials. All trials are disappearing. Bench trials have gone down faster. It's the blue line in the federal system than jury trials, which I think proves that the disappearance of jury trials is not due to some special characteristic of jury trials, either their expense or their length or the fear of runaway verdicts or the need for some kind of specialized jury trial advocacy experience. The next slide shows that last year the average federal judge in the District of Nevada tried only 1.7 civil jury trials and on average, less than one bench trial. That sounds embarrassingly low, but in fact, this district ranks 28th in the country in the terms of the number of jury trials per judge and 18th in terms of the number of bench trials per judge. One might explain the decline in the absolute number of trials per judge. And you know, these numbers are so large that it's embarrassing for them to call themselves trial judges because they clearly are not trying many cases today in the federal system. In the same, as I'm going to show you a slide in a second, it shows you the same thing is happening on the state side. But the real key factor is, if you look at the percentage of civil terminations by bench and jury trial and again in the last 55 years, it shows the exact same pattern, but this accounts for the increase or decrease in the total number of cases being filed or on the docket because it's in terms of a percentage. And as you can see, it's extremely low. And on the state side, here in Nevada, the average number of cases disposed in Nevada, the number of cases, the percentage of cases disposed of by jury trial are 0.5%, 0.6% are disposed of by a bench trial. The question we are asking, the Civil Jury Project, is why is this occurring? Do we care that it is occurring? And if so, what can we do about it? Let me mention briefly what we have accomplished over the last 3 years. We have created and maintained 2 distinct websites, one called the Civil Jury Project. This is for judges and lawyers and professionals who are involved in the justice system. One of the things you will notice today is while we don't have a huge crowd here, we are videotaping this. It will be posted immediately on our website, as have the past 17 jury improvement lunches. And so, because what the knowledge we will get from our jurors and our judges today will be valuable for others. But this is, we list on here, for example, one of the things we've done is when we set up the Jury Project was to contact judges around the country. We now have 260 judicial advisors. Simply means that the judges give us their email addresses and we are allowed to communicate with them by email. It does not endorse what we are doing. And we also send out for the last 24 months, we have published a monthly newsletter. If you signed up to attend this today, we have your email. You will get our newsletter in the future. The website describes dozens of the projects we are doing. We engage in empirical research. We have surveyed. One of the reasons I suspect that jury trials are disappearing, all trials are disappearing, is that a survey we did reflects that 80% of the people in this country, non-lawyers, are unaware of the fact that jury trials are disappearing. In fact, they think that the number of trials has gone up in the last decade rather than the lines, what the statistics actually reflect. And once they are told that trials are disappearing, they are concerned about it. We have discovered that even large corporations in their business-to-business contracts, we've surveyed, looked at all the material contracts filed with the SEC for a period of 6 months at the beginning of last year, that 57% of the contracts, the large contracts, the business-to-business contracts filed with the SEC do not waive jury trials and do not require mandatory arbitration, meaning that a large portion of corporate America still has faith in a jury as the best way of resolving factual disputes. We have interviewed general counsel of companies and have found that they are increasingly favoring jury trials over arbitration. They find that they are just as quick, just as inexpensive, and just as reliable as a decision by 3 arbitrators who you are each paying $750 an hour for their time. We are promoting innovations to be used by judges in the country. Judges, unfortunately, when we first set this up, we learned that baby judges school on the federal side, they don't even teach jury trials anymore. It's not even on the curricula. Judges have become very concerned with efficiency and being managerial and disposing of their dockets, and less concerned with actually trying cases. We are putting on seminars, full-day workshops in New York for our judicial advisors. 90 of them, state and federal judges, have already come to New York at the expense of NYU Law School for this day-long seminar on how to conduct a jury trial. And we have 2 more of these seminars, 30 judges each one, scheduled for mid-October. As I said, this is our 18th jury improvement lunch. We have lunches planned for tomorrow in Oklahoma City, Friday in Miami, and in Los Angeles, Tucson, Palm Beach, New York City, and Fort Lauderdale in October, and early November. We maintain a second website called WeThePeopleWeTheJury.com, which we try to attract jurors to come to this website by giving them, asking judge to distribute these cards to jurors when they are discharged, suggesting that if they want to talk about their experience, they can go to this website and they go and they hit on that icon at the end, served jury duty before, and they are led through a questionnaire. We have hundreds of jurors coming there and responding how they can improve the jury system. You know, it was funny when we got into this, if you stay at a hotel or eat at a restaurant, you're given a satisfaction survey. Why don't we ask for jurors' opinions around the country? It's something we certainly have to do more of. We also, and judges who are here, if you haven't picked them up, you will be given a stack of these cards, and we ask that you hand them out to your jurors. If you need more, do it. And I know that we have a lot of judges here. We can only put 3 of them on the panel because we've had a lot of jurors who are here and will share with us their experience. But the judges, we would welcome you as a judicial advisor. I just need you to communicate with me. I'll email you, since I have your email address now, about whether you will be willing to serve as a judicial advisor for this project. We're active on social media, and there's Jury Matters, and we tweet a lot, and we try to attract jurors who have received a jury summons. They find us through social media. They are surfing the web to figure out how to get out of jury duty. And when they click on this icon on the left, what they see is people like the jurors who are here today telling their stories and telling them, don't throw away your summons, report, because you're about to have one of the best experiences of your life. I have been around the country seeing thousands of jurors. They almost always love the experience. Maybe that's self-selection, they're the ones who are talking to me, but they find it a great experience and one they would like to do again, and they are willing to share with the people who have received a summons. And the hope is that by getting them to come to this site, they're coming looking for how to get out of jury service, but instead we talk them into reporting. We can improve the yield on jury summons. And of course, if they come to this site and they're currently on a jury, they're told when they hit on the middle icon, you're not supposed to be here. The judge told you you're not supposed to be here. Come back after your trial's over. This is kind of what we are doing. I have left at the table as you go out. We try to make a list of all the reasons why jury trials are disappearing. There are about 18 reasons. Half of them we can't do anything about, but the other half we can do something about. And one of the things we can do is encourage judges to conduct trials in ways that we're going to talk about today. Flexible schedules where jurors can serve on jury duty and also take care of their business. Allow jurors to ask questions. Instruct the jury at the beginning of the case on what the law is, not at the end of the case. Give each juror a copy of the instructions and the verdict form at the beginning of the case. There is a lot of experimentation going around in the country now of judges and telling jurors you are allowed to discuss the evidence before deliberations as long as everyone's present and you don't decide anything. Jurors follow those instructions, and they like that because they're going to discuss it anyway. So we are promoting, and one very important thing we are doing, I just read an article this morning, we are encouraging judges to set time limits on trials. Trials, not only have the number of trials decreased, but the length of the trials has greatly decreased. There are very few trials that last over 20 days. All the jurors who we have coming today were in very short trials. So there are a lot of shorter trials, partly because judges are setting time limits. in managing how the evidence flows and how the lawyers can make opening statements, how long they have to select to participate in voir dire. So now I would like, before we get our panel discussion underway, I would like to introduce and recognize the judges who are here today, who are not going to be on the panel. Judge Nancy Alf is here. Judge Alf. Judge Mark Bayless is here. Judge Bayless, thank you. Judge Linda Marie Bell is here. Judge Kenneth Corey. Judge Andrew Gordon is here. Gordon's a federal judge. Judge Joe Hardy from the 8th Judicial District. Judge Eric Johnson. Marianne Price. And Doug Herndon is here. Judge Herndon. And Judge Escobar is here. Thank you. Have I missed anyone? He's on the panel. So I'm gonna get to the three that are on the panel, but I hope I have not missed anyone. And I do hope we will stay in touch with each other after this is over. Judge Bell, would you say a few words to the group, since you are the chief judge of the state courts? Could I ask you to come forward and welcome the group here? We could not get the chief judge of the federal courts here, but thank you.
Thank you, everyone, for coming. As many of you know, the judges that work with me, we're one of the busiest courts in the country, and we really do try to get our cases to trial, but we're really open to anything that can improve our process. So I'm personally really looking forward to hearing what our jurors have to say. We have a committee in our court that works on those issues to make sure that we're always doing what we can to improve the process for jurors. So hopefully we'll pick up some more ideas today.
Good.
Thank you.
Thank you for coming. And now I'd like to invite to come up for the panel discussion Judge Williams, Judge Villani, Judge Boulware, and the following jurors: Connie Ackridge, Ms. Ackridge, Tabitha Gherkin, I'll never keep your name straight, Rebecca Gill, Rebecca Paddock, and William Parr. Is Mr. Parr here? Yep, here he comes. Great. Now for the jurors, let me just give you one of the little guidelines. We do not want to talk about specific judges or specific lawyers or anything about, we don't want to really talk about the details of your deliberation. We want to talk about the process. Well, how can we improve the process? And that's fair game. And we want to hear from you. We have a mix. I think the only federal juror is Mr. Parr. Anyone else serve on a federal juror? I think the rest of them are state jurors. But I think almost all of you served on civil cases, and the verdict was returned. And one of you served as a foreman, I know. Who was a foreman? Ms. Gill and Ms. Paddock were both foremen, and you were foreman too. So I try to get this information advanced to kind of know what we're talking about here. So,
and we have one judge that was a juror.
Judge Villani was actually selected as a juror.
Wow, that's
Right.
And Ms. Gill, you were selected as a juror too. You're not are you a lawyer? I know you're a political, you told me you were a political science.
I'm a political scientist, but I study law and courts, so yeah. I study judicial behavior.
But,
wow.
good.
What a great opportunity.
So when you all were served with the summons, did anyone try to figure out how you get out of it?
Yeah.
You did. And I bet I know if you go to Twitter and put in jury duty, that's all you find, or things on YouTube about how to get out of it, what to say.
I really didn't try that. I just talked to other people. I says, you know, I don't want to come downtown. I don't want to do this. I don't want to, you know, and I even had lawyers tell me, just tear it up and throw it away.
When you report, one of the complaints that a lot of jurors have mentioned, and a few of you mentioned them in the questionnaires we gave you, was that there seemed to be a lot of downtime and wasted time before you were even selected, whether it was waiting in the jury assembly room or waiting, I guess, during the jury selection process. In all of your jury selection, were the lawyers allowed to ask you questions about your views? So the lawyers participate. Were you, Ms. Parr, in the federal court you were in, were the lawyers allowed to participate in the voir dire?
I believe so. I know the judge.
To question the potential panel members? Well, this is something the lawyers know that we have been excluded from the process in federal court for several decades now because we abused it. We asked too many personal questions. We argued our case. We tried to win in voir dire or jury selection, and that was a no-no. So the judges took it over because they could do it more efficiently. Now I think about Judge Beauvoir, or do you allow the lawyers to participate in voir dire?
So my process is sort of a hybrid. When I get to the point where the lawyers can exercise their challenges, then I allow each juror is brought over to sidebar, and the lawyers are allowed 5 to 10 minutes to ask each particular juror whatever questions they want at sidebar. I do it at sidebar to avoid any sort of tainting of the entire panel, but that's after I do initial questions that the lawyers have submitted to me. When we get it down to a smaller group, the lawyers are allowed to ask questions of each juror individually at sidebar for about 10 to 15 minutes.
In your state courts here, what information are the lawyers provided about the potential jurors before jury selection begins? Judge Villani?
The jury list that we receive from our jury commissioner will identify if they're married, their occupation, their spouse's occupation, number of children they have, years residence, years of education, and prior jury service.
And age.
And age.
And their age.
And ethnic background.
So, would you have problems? Some jurisdictions now are getting more information from potential jurors before you even come to the courthouse by questionnaires on the internet. I mean, you're summoned by email, and then you're asked to fill out a questionnaire. Maybe even look at a movie, a video that explains what jury duty is about, so that by the time you arrive at the courthouse, you know how long the case is going to last. You know something about more than just coming and waiting. Would any of you have any problem with completing that information in advance? Does that cause you any kind of privacy concerns? Okay.
Yes.
Did you feel?
More efficient.
Yeah, go ahead.
I think it would make it more efficient to have the questionnaires. I'm also a lawyer, so I.
Oh,
can
you're a
see
lawyer
the other
too.
side.
Amazing.
And I think the process of voir dire or jury selection would be much more efficient if we had more information up front.
Judges, would you, if the lawyers can agree on a questionnaire, a more detailed questionnaire, tailored to the specific case, would you be willing to submit that to the Veneri panel to fill out in advance?
I would. I mean, I think part of the issue, sometimes we have jurors that get excused for cause because of their employment, right? They may work. Like I had a case involving a correction officer And one of the jurors was working with this at the correction facility, right? So it seems to me that there might be certain types of questions where you think it might be likely that the juror might be excused for cause, not because they were biased, but because they may know this person or may have particular information that you think, or the lawyers would think would be inappropriate. So it does seem to me that the lawyers might be able to agree upon questions that could be asked that might allow for jurors not to have to show up, not have to wait to get into the box and then answer the question about their background employment and then be told, well, thank you, but you're going to be excused.
I have.
All of us, yes, go ahead. Judge.
I probably utilize questionnaires on probably 50% of my cases that go to trial. One of the issues we're really dealing with right now on a state court level, we have a jury improvement commission. I happen to be on it along with Judge Milani. And one of the issues we're looking at, we're trying to devise a way where lawyers can actually submit their jury questionnaires that are case-specific and individual to the jury commission and have those answered via internet, somewhat similar to what you're talking about, in
Yes.
order to save time for case-specific questionnaires. And we're looking at that right now. We don't have an answer yet, but we think we can do it.
So if I had one question that I wanted to ask potential jurors before they came to court, which person, living or dead, do you most admire?
Yes. What would I do with that?
Would you let the jurors, the lawyers ask that question? Was that an appropriate question?
I'll tell you what I think the appropriate answer would be for two reasons. No, I'm serious, and this is often overlooked. See, Nevada is a much different state than other jurisdictions on a state court level when it comes to voir dire. We have probably about 22, 23 published decisions specifically dealing with that issue. But just as important, we have Nevada adopted quite different than the model rules, but we have Nevada Rule of Professional Responsibility 3.5E. And if you look at the rule, and what the rule stands for is this: a lawyer cannot conduct any type of activity that results in indirect or direct communication outside of court. But the rule says this: they can investigate any basis for challenge. And it's broad in its nature. It doesn't say investigate cause challenges, any basis for challenge. And we have cases that say, look, you can, the types of questions for peremptory challenge exercise and a challenge for cause are different. I'd let them do it. I'm just telling you.
Yes, I mean, the jury, we have the Civil Jury Project. Another thing we did, we recruited about 35 jury consultants from around the country, jury trial consultants, they call themselves. And what they have told us is that a question like, where do you get your news?
Right.
And which person, living or dead, do you most admire, are more important than almost any other question you can ask people. It's
Just
not
make it
re-
3 questions then, right?
it's not really invasive. Now, another issue that has come up, and I would like to ask the jurors what they think of this, is if your names are provided to the lawyers in the case in advance of your coming to the courthouse, or even before a lunch, and you come back after lunch, the lawyers can look you up on the internet. And everyone has a big footprint today on social media and else, you know, I could look, Ms. Ackridge, I could look a lot up about you and find out about whether you're a Democrat or Republican, how much you paid for your house, what neighborhood you live in, what bumper stickers are on your cars. A lot. And the bar, as you know, the judges around the country are having a difficult time dealing with this issue because there is an ethical prohibition against a lawyer communicating with a juror. But most of the ethical rules that are coming out from the state bar committees now say that as long as you don't befriend someone, as long as, and certainly as long as they don't have a footprint, I mean, they aren't told that you're looking at them, that it's okay. It would be like driving by a juror's house in a car. You know, if you knew where they live, you could drive by their house and see what's on the bumper stickers, what kind of house they live in, et cetera. And of course, lawyers are doing this. Well, how do you jurors feel about that? Do you think that would be an invasion of your privacy, or is it something you just expect? that they're going to see what you are doing on Facebook, on Instagram, you know, Ms. Ackridge.
I think as long as you are the one that puts the information on the internet and you know that by doing that, you know it's a public information, but with all of the issues about the tech people collecting more and more information on you and what's going to be available, even despite, you know, what you may think about that's a little bit troublesome, I guess, in the future, that they would, you know, that information would somehow be available for sale or otherwise, you know, for you as for people who are trying cases.
Yes, I mean, and the lawyers could be told that whatever information you gather, it's got to be destroyed. They can certainly be told that after the jury is selected. So, and we have an obligation to destroy things. We're frequently privy to very sensitive business records, and a protective order is entered that require, after the case is over, we destroy everything we see, and we can't disclose it. Ms. Gerken,
I think
Well-
it's inappropriate, but it's expected.
expected.
You said it was inappropriate?
I think it's inappropriate.
Why would you say that?
Wow.
Because you're asking the jurors who are taking time out of their life to be down here, who can't talk to their spouses, they can't talk to their friends, you're asking them to be impartial. But then there's other people that they don't know, that they've never met, getting to judge them from the outside by what they have on social media or what, you know, what they have via the assessor's page or whatever. And so I think it's inappropriate, but I would expect it anyway, whether it's appropriate or not.
Would you expect the judges to warn you that it may happen? Because you know, this is one of the issues comes up in instructions, is whether or not you should say something to jurors. So I don't know whether or not you all would appreciate as jurors being told the lawyers are permitted to be able to review things you may place on social media, whether or not that would encourage people to suddenly shut down their sites. And so I've actually struggled a little bit with that because I don't know. I think it may warn people because, like Ms. Gerken, they've had a concern. But on the other hand, the lawyers say to me, well, if you say that, Judge, then we may not get access to the information that we want to have. So I don't know how the jurors would feel about that.
Yeah, and one of the judges, by the way, Judge Alsop in San Francisco, a federal judge in the Northern District of California, he's very much opposed to lawyers doing the research because he says he doesn't want it to be reciprocated by jurors. Jurors are not supposed to look up the lawyers. I mean, and I would certainly understand if I were trying a case that the people on the jury might Google Steve Sussman to see where he's from, what he's done in his life, you know, but you're told by the judge not to do that.
Steve, we had a scenario in trial where we give the prohibition about, you know, no communication, you can't talk about the case, but we had one panel member during voir dire that each night would get on Facebook or Twitter and talk about the case. I think, weren't you involved in that case, Mr. Henriade?
I was, Judge.
It rings a bell, doesn't it? It was early on in the voir dire process, but I think what happened, the lawyers each night were checking the panel members. And we had one panel member that was actually, I think you were involved in that case, and they were specifically not tweeting, but they were posting on Facebook with their friends. They had opinions on the lawyers, on the judge, on the trial consultant. You remember that, Mr. Henriade?
Yeah.
Yes.
That was actually during trial.
During trial?
Yeah, that sure is a hot trial consultant, and yeah.
Yes.
that's
Well, you
the
were
one.
involved in that case.
Yeah, I was.
You were on in the case?
Well, she's a lawyer, too. She's a juror and lawyer.
Oh, you're a lawyer too?
Yes.
How did all these lawyers and judges get on the jury around here?
I have jury duty next month.
It's amazing. Well, so let me ask the group, do you think that the selection process that was used in your trial disclosed biases, your own, or biases of other jurors that you saw during the deliberations or during the course of the trial? Did you think that people got on the jury that probably shouldn't have been on that jury? Or was it effective? Did you think the selection process was effective in weeding out those people? Anyone have any thoughts about that?
I think that it was effective, at least for the jury that I was on. In terms of the final jury panel, they all seemed very fair. We had a quite interesting panel of like, it was a PI accident reconstruction, all kinds of these, you know, nurses, all kinds of people that you would never expect on a jury. So I think it was a lot of process of kicking people off, but
So-
hopefully I think the end was.
So after you're selected, get on the jury. And- Well, let me ask you another innovation we have thought about. Several judges in the country are now trying this out, asking the lawyers to make their complete opening statements, their opening positions, instead of waiting till after the jury is seated in the box, the 12 or 8 or however many the judge is going to sit in a particular trial. The lawyers are asked to make their opening statement to the entire 50 or 60 who sit in the courtroom going through this jury selection process. The judges and lawyers who have done this like it because they think it makes for a better voir dire jury selection, better questions. If the people who are called hear more about the case. When we ask people who have heard, none of you did that here, or I assume none of the I haven't heard of it going on here. But what would you think, Ms. Gerken, for example, what would you think about a situation where you got to hear the opening statement before jury selection?
For the group that I was with, I think all of us probably would have decided that day if they had given their opening statement.
You would have decided the case.
We would have decided the case that day.
Well, maybe that's, but you had to go through a trial to decide the case.
We did.
But it was a quick decision at the end?
It was a quick decision.
Yeah. So, I mean, that's probably a case that should not have gone to trial. Which happens in our system, obviously. And I think I saw some of your comments that it was a case that should never have gone there. Judges, an innovation that we are urging judges to consider is to give jurors an instruction about the law at the beginning of the trial. You know, this jury service is funny. It's the only, whoever tries to put together a puzzle or a piece of equipment without reading the instructions first. And yet, in this funny thing about jury selections, you hear it all and you don't get the instructions until the end. So would anyone have liked to have had more instructions or a list of the questions that you were going to have to answer at the front end rather than the back end?
Well,
Go ahead, Judge.
I believe that the majority of the judges in Nevada state court judges here give preliminary instructions. After the jury's impaneled, I always give some preliminary instructions to give them an idea what to expect during the trial. We give them some discussions about the witnesses, the testimony. I mean, not specifics of the testimony, but who the witnesses are going to be, how to judge their credibility, and the procedure that's going to be followed during the trial. So they have a better understanding.
Right.
And also we advise them that they are allowed to ask questions of any of the witnesses called to testify.
Well-
Also, before, or when we impanel the jury, we also advise them not to do any research, internet research on the case or anyone involved in the case.
And I give the full substantive instructions before.
You give all the full, basically you give them fully at the beginning and the same ones you give at the end.
Well, yeah.
And I mean, they may be
It may
modified.
be modified by the evidence, but I give on the substantive claims or counts,
Right.
I give those instructions.
To prove fraud, you have to prove that there was a
Before the
false.
openings, I give
Yeah, you tell them all that, the elements, the substantive elements. And Judge Villani, you don't do that. I mean, you're just telling them about how they judge credibility and the burden of proof and things like that.
Correct.
Do you judges give each juror a copy of the instructions in writing
For deliberations, yes.
Yes.
for their deliberations? Do each of them get a copy of the verdict form?
No. We give one verdict form.
One verdict form. Why is that? Why don't we provide them each a verdict form? What's the problem?
Well, I think I expect they're only going to use one, so I don't give them multiple verdict forms. The only time where I've done it in one case where I gave multiple forms where there are like 8 or 9 different counts.
Right.
And so I think it was helpful for them thinking about it. But in the other civil case I've had, there haven't been that many counts, and so I found it useful to give them all the verdict forms only when there were so many different counts. They had to sort of think about the evidence differently.
Now, one of you told me on the questionnaire, who filled out this little questionnaire, that you would have really thought you would have benefited by the ability to ask questions of witnesses. Who was that?
That was me.
That was you.
Yeah,
So you were in a state court where that was not permitted.
right.
It should have been permitted, right?
I don't think it was permitted.
So here in Nevada, a state court where it was
Yes.
not permitted.
No, in the state court, we permit questions while the witness is on the stand,
They
uniformly.
do it in writing, they submit the
They
questions in
submit
writing.
the question to the judge will review it.
And is that a rule that provides that, or just a common practice? I mean, are you saying that all judges do it?
Don't we
so-
all do it?
Yes.
It was a few years ago. Yeah.
So it's very common now. This is a practice that's getting more and more common. Judge Boulware, do you allow it in federal court?
I don't.
Why
I think
not?
There's only one judge. There's one judge in federal court. I think Chief Judge Navarro actually permits in our district the jurors to ask questions. And so I've actually thought about it. I've actually talked with her about asking questions. And I've asked some of the jurors I've had, and some of them said they would have liked it. Some of them said that I've heard some feedback that said that they would have been distracted about thinking about the questions. And so I'm curious to hear about what other people think about answering the questions. But I've asked a couple of jurors about that process. But I've been thinking about it.
Were y'all all allowed to ask questions down there?
No, we were not allowed to ask questions.
Not in your court, not in the court.
I believe it was that they said we could put it
You
in
believe
writing.
you had the ability to ask questions? Our studies indicate that jurors love it because it keeps them involved. It's so easy to fall asleep. It's good to think about, can I come up with, what would I like to know more? Judges typically don't like it for two reasons. One, I don't think either of them are meritorious. One is that it takes up too much time. But whenever I've been in a trial, it's a very quick process. At the end of a witness, every juror has a blank piece of paper. You pass your piece of paper, whether you've written any questions or not, to the bailiff or the marshal, who gathers them all up so the lawyers can't tell who the question is coming from. And the judge looks at them all, and maybe out of 12 blank pieces of paper, there'll be one question or two questions. Almost always, sometimes a question is improper, seeking what's not,
Right.
where you're covered by insurance. What about attorney's fees? Who's paying attorney's fees? There's some things, that are not to be discussed because of the rules of evidence. But that doesn't happen very often. The other objection that judges have made is that it allows the lawyers to know how they're doing. To me, that's the greatest benefit of asking the questions. The common theme that runs through the jurors' answers, or your answers too, to your little questionnaire, was that it was very repetitive. The trial lasted longer than it needed to because we knew right away who was going to win, or the lawyers just repeat themselves. Well, if the lawyers knew how well they were doing, or whether they knew what they were getting across or what they weren't getting across, maybe we could cut down some of the repetition. So allowing the jurors to ask questions is becoming very, very popular around the country. There's another practice, though, I wanted to ask you about. By the way, do you think that, I'm not asking, do you think jurors mind the instruction that they're not to go on the internet and look up anything? What is your feeling? I don't want you to confess guilt, but I mean, that's,
followed the directions.
huh?
I followed the directions.
What?
I did.
You did?
I followed the direction.
You followed the directions. Well, I mean, I know you
I
did.
think the rest
Do you
of the-
think everyone else did?
On my jury, I think so.
Pretty much? I mean, none of them are bringing back information
No.
that,
No,
Sandra, where'd you get that from?
no.
So there's another thing that judges tell jurors: you're not to discuss with each other the evidence, either at lunch or in the jury room, until you all are present for the deliberations at the end of the case. Some courts around the country are telling jurors, you are free to discuss the evidence as long as everyone is present when the discussion takes place, and as long as you don't take a vote. You're not deciding the case. You know, everyone's sitting in the jury room, time's being wasted, the judge had something else to do, you're back there all together. What's wrong with jurors saying, that last witness didn't seem to have a very good memory, or I didn't believe a thing he said, did you? Or, did you understand, what was she saying about something? You know, you didn't hear it exactly. So what do you think about that practice? I assume that is not allowed in this jurisdiction.
No. I think it's a terrible practice.
Why?
Because we tell all of our jurors, wait till the end of the trial to hear all the evidence in case before you start to make your mind up what decision you're going to make. If they start discussing it after 2 or 3 witnesses, they may make up their mind because these are plaintiff's witnesses. It's not fair to the defense. Also, in that discussion, you may have an alternate who will not be present during the deliberations, and the jurors who are trying the case are going to receive an opinion from someone who's not part of the deliberations. So I think it's very inappropriate.
Yeah, and I agree with Judge Villani. One other point, they haven't been instructed on the law yet until deliberations, and consequently, how can you decide or have opinions as to which way the case will go until you've heard all the evidence and been instructed on what the law is? So I agree with Judge Villani on that.
And I also agree, I think in part because the main purpose they may have in discussing is to try to reach a verdict faster. So it doesn't seem to me that they're just going to want to talk about it idly, that the purpose of having the conversation is, even if they're not reaching a final vote, is to reach decisions along the way that will help them expedite it. And so the question is, how do you avoid them essentially pressuring each other to say, look, do we all agree that that witness wasn't believable? Okay, so we can discount that witness when we're not delivering, but when we begin to deliberate. And so it does seem to me that you'd have to have some more specific instructions. I think it would be perfectly appropriate if someone didn't hear something, potentially, to allow a juror to tell someone what they heard. I don't think that they should discuss evidence, but if someone genuinely didn't hear something, that would, I don't know that wouldn't necessarily be inappropriate, but it does seem to me if you have them all together discussing, that the point of them discussing is to reach the deliberation. And also I think one of the main things that you've said that jurors are really interested in is getting finished as quickly as possible. So I think they'll use those discussions to expedite their deliberation process, and that's why I would be opposed to that.
Okay, so let's talk about the getting finished as quickly as possible. There was an article that just came out that actually is published in this month's newsletter that we send out, the Civil Jury Project. The jury consultant discusses the difference between evidence-driven verdicts and evidence-driven deliberation and verdict-driven deliberation. The verdict-driven deliberation is where they all come back and they go around the room and say, let's vote before any discussion. And they have a straw vote. And the evidence-driven deliberation is where they go around the table, everyone says they give their opinion, they talk about the evidence before there's any vote. The empirical research that's been done is that the jurors seem to be more satisfied when they do an evidence-driven deliberation, because once they vote, it's hard to change people's mind. If you go around the table and you get a vote of 9 out of 10 jurors, there's not going to be a lot of discussion at that point in time. That it's better to give everyone an opportunity to talk. And so the judge could give instructions, but very few do, to the jury that please do not conduct a straw vote until you each have talked about what you think about the case and the evidence. You know, because if you do, it's likely to be difficult that you will hear everyone's opinions. I mean, any thought about, I don't know how your deliberations went. Did y'all all conduct a straw vote at the beginning?
I absolutely agree. I obviously didn't realize how it worked until I got back there and we did the vote. And by the time you get to the end, last person, even if they are maybe having their own opinion, it's going to be difficult. And my trial was short, but we had camaraderie by the end. You know, it was less than a week or a little over a week. And so you know these people, and I think it was much more, and we were an open group. It wasn't like they were bullies, but it was much more difficult, I think, if someone had a different opinion. Now, it wasn't a super controversial case, so I imagine in different scenarios it might have had a different outcome, but definitely that was something that I took away from as far as telling, if I were to do a, trial and tell them just don't vote that way.
Because it will shut down all discussion. Anyone else have yes? Ms. Gill.
Ours was kind of a straw vote, but as it came around, I had to say I have reasonable doubt, and I would like to discuss, and then it got other people that also said, yes, I think I do too, and then we had a very good discussion about it. It went fairly quick, but it was still, there was discussion,
Ms.
and
Gill?
I wasn't going to let it just, we're not going to give this guy, a sentence without discussing it.
Okay.
Let's talk about it.
Ms. Gill, what was your experience?
Well, I would echo what Rebecca said, that I think what we did is we wrote something down first, but it didn't have to be, yes or no. It could also include, I'm not sure. And so the idea was to say, like, where are we starting from? Because I was concerned that going around the table, that people farther down the table would start to feel pressure. So, and especially I didn't want to speak first. So, so that's why I did it, to sort of avoid the situation where at the
Did
end,
what? What, you were the foreman?
Yeah.
What did you do?
So we took a straw
You took a
poll,
straw
but,
vote.
with the option to say, I'm not sure. Or I'm leaning to letting people hedge.
Were they all unanimous on the straw vote? Yeah, well, don't tell me that. But yours was a quick case? How long did it take you to deliberate?
Yeah, it was.
Quick.
We enjoyed our lunch and then.
I got it.
But I was concerned that people would feel pressure, that social pressure. So.
How did you get selected?
I'm a professor, I guess. They thought I was professorly.
What?
So that's how I got picked, I guess.
Is the foreperson?
Yeah.
How were you picked as a foreperson?
She's a professor.
They voted.
Oh,
and
because you're a professor.
I think so. Or,
Yeah.
I mean, and I took
And
like Madisonian.
you were a
notes,
foreperson. How were you selected?
Kind of the same way you're the attorney in the room, so you're going to be the foreperson.
Because you were the attorney.
Right. Could I mention something about this straw vote
Yes.
issue? Because I was asked my husband on the way over. He's sat through he was on a jury for 2 capital murder trials. I said, what would you change? He said, he was talking about this straw vote, and he goes, I think that should be anonymous. Like, let's just, everybody vote, but let's throw it in a bucket so no one knows who voted which way. Then there's no pressure about, changing your position, but you can still get a sense for, sort of how
Okay.
the group would
That's
go.
fair.
Yeah.
That's what we did.
So you wrote it
Oh,
down
that
on
you
a piece
did
of
that?
Yeah.
You did
Oh, yeah.
anonymous?
Oh, yeah.
So-
Okay.
So my question is, would it have helped you to have a little more direction from the judge on how to conduct the deliberations? Like if you can do a straw vote, but you should do it anonymously. The danger of doing it is that not everyone gets heard, that you should probably not do that in the first 30 minutes or hour or something like that. You got to listen to everyone because a lot to be gained by listening. Would it be helpful for the judge to have some instructions? And would the judges be open to giving a little more guidance on how jurors should conduct the deliberations?
I'd be open to that. I had not heard this about the voting Sadly, I feel like the only judge who hasn't been selected for jury duty. I don't know that it would necessarily have to look at case law, but I don't think it would necessarily be a violation of any sort of precedent for us to encourage the jurors to, if they're going to vote initially, to do it anonymously and to make sure that everyone's heard before they render a final verdict, as opposed to striking a strict sort of roll call vote ahead of time. I think that might actually be helpful to encourage deliberation and to give them some structure, because I do think one of the things about, at least I've heard from jurors, is they go back there and no one really tells them how to deliberate. So they'll select a four-person, we don't really tell them, you should vote, but you don't really tell them how, is there a nomination process?
Yes, sir.
So that's what I heard.
Go ahead.
Go ahead.
So the judge, it sounds like in your case, the judge could have been more helpful at the beginning, explaining what the law is, with preliminary instructions. The empirical evidence, the studies that have been made, and this has been studied, is that foreman, the foreperson, has an oversized impact on a close case. That the foreperson, the identity of the foreperson, makes a real difference if it's close. Now, a lot of cases aren't close. You know, your case obviously was not close, Ms. Gill. I mean, it wasn't. I mean, but some people do, and the deliberations go on for days. Did anyone deliberate for more than one day? How many days did you deliberate?
I think we were like 3 or 4 days.
3 or 4 days
Yeah.
deliberating. How long was the trial
It
itself?
was a week. Yeah, it was a week long.
Okay, but that's a long time. Someone mentioned the jurors anxious to get out of there. But then someone also mentioned in one of their questionnaire, one of you jurors mentioned that you were on a schedule where the trial only lasted 1 to 3 hours, 1 to 3 hours per day. Who was that?
That was me.
Okay, tell us about that, Ms. Paddock.
Well, I personally enjoyed it, and I think some of the other jurors, though, I had a little bit easier time because when I was done on jury duty, I could just walk across the street to my office where everyone else had to drive home or drive to their various jobs. But I know our longest day was voir dire, and the jurors that ended up getting picked were very, exhausted by the end, and this was, very difficult for them to have sat through an entire day. And I just felt that the 1 to 3 hours, though in my experience when I do trials, we never just go 1 to 3 hours. We go, 5 hours, 6 hours, something like that. But I thought it ended up working out better because then the jurors could go back and do a lot of our jurors.
What were the hours you worked?
Hours that I worked?
No, I mean, what the jury worked. You say, was it the same amount of time every day?
No, it wasn't necessarily on purpose. I think it was because of different witness issues or whatever, but it was somewhere between 1 and 3 hours.
What judges are doing a lot around the country now, and I don't know whether they're doing it here, is they are conducting the trial like from 8 in the morning or 8:30 to 2 or 1:30 with no lunch break, but 2 15-minute bathroom breaks and maybe a 15-minute snack. Bring in some snacks for the jurors. So yes, sir, Judge Williams.
I hadn't thought about this till you mentioned it, but Rebecca, she served on a jury, and as trial judges, you're trying to be efficient and marshal the case home. But maybe a better way to do it is to have your jury trial starting at 1 o'clock in the afternoon, half days. I'm not sure, but is that your opinion?
That'd be my opinion. Yeah, I thought it was helpful. And then for people who had, obviously, if you're on a job where, you have certain hours and you have to take that time off, that's one thing. But a lot of the people on my jury had more of independent type of jobs or flexible schedules, so they were still able to work at least half the day or part of the day.
And I found I've done a few of the abbreviated, like the shorter schedule, like 8 to 1 or 2. And I find for parents, right, that time works out well, where they can drop their kids off if they're also involved in picking the kids up. And so if you finish somewhere around 2, around that time or earlier, and just have a few breaks, I've noticed a lot of people preferred that. When I did that on a trial, and they really liked that schedule.
I mean, it allows people who have jobs that they are very important to do their jobs for part of the day. Fewer excuses for hardship.
Right, economic hardship.
Yes, Judge.
I would think that jurors would want to complete the trial as quick as possible. You know, why make a 3.5-day trial 5 days by doing that? You know, for all of the judges, at least I'm aware of here in Las Vegas, after our morning calendars, we typically would take a 15-20-minute break. So maybe we start at 10 or 10:30 each morning and go until 5. And so I think if you're only putting 3 or 4 hours in per day, and you've made, like I said, a 3-day trial of 5 days, and I think a juror would rather get out of there after 3 days than wait 5 days. And we take break, in my court, I take breaks every hour and a half, hour and 45 minutes. We always take a mid-afternoon break, lunch break, obviously. On Monday, we would start at 9 o'clock. Otherwise, it's always after my morning calendar.
Ms. Ackridge, if you were first place, do you want to do it again?
Sure, that was awesome. I would do it again.
You liked it?
Yeah.
If you could change one thing, what would you change?
Yeah, I think the whole notion of sort of telling people, giving them more information up front so you can kind of follow what the action is and it has more relevance to you. I think that is a key to kind of making the process.
Ms. Gherkin, do you want to do it again?
I would do it again.
And what single thing?
I have a
Would-
whole list of complaints about the entire first day.
Tell me about it. Tell us about it.
So, I'm not one who's like, oh, men and women, whatever, but as a woman, and I never ever say that in my life ever, as a woman though, walking from the parking, which is 5 blocks away, over to the Regional Justice Center, the catcalling, the blind alleyways, and I'm not a defenseless person. I know how to defend myself. I was terrified. And I thought I couldn't bring my phone because the online thing says no phones in the courtroom. So I took, during one of my breaks, I went back to the car just so I could talk to my husband. And he knew I was alive, because I don't do Fremont Street, but otherwise I don't walk around down here. So the parking is, and I think for anybody, but it's kind of scary to walk around and deal with that 5 block
Okay.
walk. The check-in process where everyone's sitting down, and then everyone has to get back up to go check in and get their parking validated, and then sit back down, and then get back up to move because these people got moved out and stuff. It's very tedious. Why they can't just check everybody in as they're coming in and save probably at least an hour of time, and then I got put into the actual courtroom just before lunch. So we get in there, and then you have to go to have lunch for an hour and a half. So the whole day, there's a lot of lost time that's just exhausting.
Anything else you can think? By the way, how many of you were asked to complete a questionnaire after you served by the judge or anyone at the courthouse about what you liked or didn't like or what could be improved? Yes, sir. You were interviewed by what? In a civil case or a criminal case? Oh, yeah, well, but you were asked about the particular case, right? My question is about the kind of questions like you there's not an opportunity to give your ideas to improve the system, a suggestion box, a customer satisfaction survey, something we can do more of. Ms. Paddock, what would you do?
I think
having more information up front, jury, the jury instructions, or just more information about the case up front. And as the only lawyer in our jury, every time we were on a break, the jurors were like, knew that they couldn't talk about the case, but would try to ask me questions like, what about, and I'm like, I could tell that they all wanted to know how they should be analyzing this information. And frankly, I don't practice civil law, so I wouldn't even have an answer anyways, but I was also interested. I think it would have been more helpful in terms of knowing what the law was and that ahead of time.
Judge?
I just have one comment. I think this kind of mirrors one issue that you talked about back in New York regarding maybe between the witnesses, the lawyers have a brief 3-minute statement as to what they anticipate the witness will talk about and what the evidence will be.
Interim statements
Interim
by the
statements,
lawyers.
yes.
That's another. I didn't have, none of you had that in your trial, right? Mr. Parr, how about you? I take it you would like to do it again.
Oh, yes, of course.
Mr. Parr,
Oh, I thought it was a wonderful experience.
what would be the one thing that we should change?
It would just have to be in the beginning of picking the jury. It was long, tedious, and it just seemed like 50 or 60 people, at some point in time, some of them could have gone home. There was
So-
not enough seating. There was
One of the things I think that the judges need to think about is maybe we can have a questionnaire that makes that process go much quicker. And even, frankly, trial lawyers will disagree. I have trial lawyers in my own firm that say, I need to see them in person. I need to meet them. I need to hear them talk. But I would rather have a questionnaire than the opportunity to ask any questions of them, because I think you can find out a lot from a questionnaire. Ms. Gill, how about you?
Well, I think if you're interested in having the deliberations be perhaps a little shorter and the jurors being more engaged, I think putting out a framework ahead of time about what the law requires and what the case is about, because that allows the jurors to interpret the evidence as it's coming in, or, oh, this is what this is probably going to be, and that helps them retain the information, it helps them make sense of it, and it helps to keep the information that comes early on from getting lost under what comes later.
Judge Villani, you were a jury. I forgot about that. A juror.
Yes.
How about you, from the inside? You would like to do it. I think you found it a worthwhile experience.
Oh, absolutely.
So what did you learn from this experience that you could use in improving jury trials?
Well, I think one of the things that some of the jurors didn't understand was the downtime. I was aware, as a judge and as an attorney, I knew that if there was downtime, it's because there was a legal issue that had to be resolved, a problem with the witness or what have you. And so sometimes, we might have to wait an extra 15 or 20 minutes, and a lot of jurors, question why. And so I always tell my jurors now that while you're waiting, we are working. So I give them that little phrase so they know we're just not back there chit-chatting, that there's something important going on, and that's why there's a delay. Other than that, I knew the system. One of the things, if we go back about as far as picking the foreperson, when we went to my deliberation room, everyone looked to me and says, well, will you be the foreperson? And I specifically stated that I did not want to be the foreperson because I didn't want to have any issue that I was controlling the deliberations. And then so someone else volunteered to do that.
Right.
After the trial, an investigator for one of the losing side was questioning the jurors out in the hallway, and I was there, and they asked, did Judge Villani control the deliberations? And everyone said no, because I didn't, but I gave my opinion, but that was a concern that I had, and that's why I specifically told them I was not going to be the foreperson.
There are judges around the country that will tell the lawyers there will be no sidebars in my court. Any issue you have has got to be raised in the morning before the jury gets there, or it's raised at lunch, or it's raised in the afternoon. other judges tend to keep jurors waiting in the jury room while they're working out these problems. So what would you think about just telling the lawyers in your courtroom to avoid this problem of having to sit around while nothing's going on, since you won't let your jurors discuss the evidence? I mean, you're not going to let them do that. I understand your reason for that. How about just avoiding them having any downtime back there by telling the lawyers, no sidebars in my court. You got some evidence, you better raise it early or you can raise it in the afternoon. How about that? Judge Boulware, would you do that?
No. I think that sidebars can be very useful, particularly to address issues where you've had motions and limiting orders and people are veering into areas where they need to be guided back and they need some instruction. I do think when to address the downtime, one of the things after having this discussion I might think about doing is giving a copy of my preliminary substantive instructions to each of the jurors so they can actually go back over what the substantive counts are in their downtime. So what they may be able to do in their downtime is look through what the different counts are and think about what might be something they could sort of talk about or think about in the downtime. But I do think if you gave them that, and I don't know how the jurors, but if I gave the jurors, each of them, their own copy of the instructions at the beginning, they could make notes, and then after, when they had downtime, they could go back and make notes, and certainly I would say to them, you were allowed to do that if you wanted to do that. So I might do that.
If I take it, you might allow jurors to discuss certain things when they're back in the jury room. One might be, I didn't hear this. What did that witness say? Did you ever hear that witness mention whether he had ever been to this place on the day in question? Or, you would kind of allow them to do that. Might you also allow them to discuss your instructions? Does anyone understand what the judge means by when he puts here, reasonable doubt or, the preponderance? What does preponderance mean? Would you allow them to do that?
Now that you asked that, I'm thinking about that. I'm thinking it depends on what the nature of the question is.
Right.
So, for example, if I gave preliminary instructions and it turns out they didn't really understand parts of them, such that it wasn't helpful to them as they were listening to evidence, I might allow them to ask questions at the beginning to help clarify what certain things meant in the instructions even before they received evidence so that they weren't clear. Again, I'm not sure I would do that, but it does make sense to me that it might make sense to ask him after preliminary instructions, do you have any questions about that or do you understand that? Again, before there's particular evidence, because I think once the evidence comes in, then it might be a little bit different because then you're having issues potentially regarding deliberations and other questions about the evidence, but maybe in the beginning permitting some question about that.
Judge Williams.
Regarding that specific issue, I do permit basic questions regarding the different standards of proof, for example, in a civil case, preponderance of the evidence. And I let lawyers ask questions about that during voir dire or jury selection, because I think it's important for the panel as a whole to understand that, this isn't a criminal case, this is a civil case, and there's different standards involved there. Just as important, too, I like to make sure I spend a lot of time with a panel to make sure they understand what jury instructions are, because I think that's so important. And we talk about jury instructions, I call them the rule of law as far as the case is concerned, and they need to know that. But like in criminal cases, I've never done a criminal trial, but I know what the lawyers do, they death penalty qualify jurors, in the jury selection to make sure they understand it's a death penalty case, and they got to know what the law is going to be when it comes to those specific issues. So I don't see where it's a real big issue.
Let me thank our panelists today, jurors and judges, for coming here and sharing these ideas. There's a lot of food for thought. I learned things at each of these that we kind of take around the country and share with other groups of judges and jurors and lawyers. Thank you very much for coming. The audience, yes, ma'am.
Is there anything that you would like to ask
the lawyers? Yes. After you decided the case or before?
After it was decided, we were able to question them.
See, I think the biggest issue, you can tell me if you agree with it, is downtime.
Improvement, and one of them, jurors, we didn't have the attorneys, please don't drag your feet when you walk across the court. It's irritating. But, I didn't hear anybody mention anything about that kind of thing happening. That was my first federal trial.
So that would be like the intermediate
When,
statements that he was talking about.
when the case is over, I'll follow up with the panel. When your cases were over, did the judge encourage you or what discourage you or say something about your talking to the lawyers who were involved? You were free to talk to them if you wished. Were you told that?
We were encouraged to.
You were encouraged to, and do you all talk to them in the courtroom,
In the hallway.
in the hall,
Yeah.
but at the courthouse? Okay, but none of the judges forbid you from talking to the lawyers. It just, the problem with that is the trials I've been in, jurors are anxious to get home. There's a winner and a loser that comes to them in the courtroom. I mean, a winning lawyer and a losing lawyer. It's awkward frequently. Ms. Gill?
I had the losing side. The actual litigants followed me out of the courthouse and stopped me on the steps. I think our discussion ended with, "Good day, ma'am." So it was not.
Thank you very much for coming. I hope you enjoyed it, and thank the panelists for a great program.